Mr. Berry.
May it please the board. This is a motion for entry of judgment against Mark Adrian Clark pursuant to Part 2 of the Texas Rules of Disciplinary Procedure. Mr. Clark was...
Sorry. Graham.
Graham, I'm sorry. I am sorry, I beg your pardon. Part 9. The reciprocal disciplinary procedure pursuant to Part 9. Mr. Clark was... Mr. Graham, sorry again, was sanctioned in Florida for professional misconduct and received a 3-year active suspension in that state for violations of trust account regulations. I will let Mr. Irwin make an opening statement and before I put on my brief.
Thank you. Mr. Irwin.
Thank you very much. Good morning. May it please the board. My name is Jess Irwin, and I'm here today representing Claude Robert Graham in this reciprocal discipline matter. I'm going to try to make this part very quick. I took the chairman's message to heart. As Ms. DeBerry said, Mr. Graham was suspended by the Supreme Court of Florida for 3 years, active suspension. That was effective December the 22nd of 2011. The commission filed its petition for reciprocal discipline that brings us all here today on August the 29th of 2014, this year. That's about 2 years and 8 months after the inception of Mr. Graham's Florida suspension. The commission now asks this board to impose reciprocal discipline identical to that was imposed by the Supreme Court of Florida. Presumably, that means 3 years of active suspension beginning now for Mr. Graham in Texas. The documents from the Florida disciplinary proceeding establish, for purposes of this hearing, a number of highly relevant facts. I'm not going to go through all of those facts now, but with the forbearance of the board, I may do that at the end of the case. But I do want to point out a couple of things. In the Florida case, which was resolved by a consent judgment, which is a procedure Florida uses, there were a number of findings agreed to by bar counsel, excuse me, and by counsel for Mr. Graham. That consent judgment was then reviewed by a referee appointed by the Supreme Court of Florida. The referee approved of the consent judgment and incorporated it by reference into his referee's report. The referee's report then went to the Supreme Court of Florida, which accepted the referee's report and imposed the sanction in a 1-page, 3/4 of a page order. So, stepping back 3 times, Supreme Court's order, referee's report, which is accepted by the Supreme Court, consent judgment, plea of guilty, which was accepted and incorporated by the referee in the referee's report. These findings are found, and this will be in the record. The shortages in Mr. Graham's trust account, and I quote, were the product of his grossly negligent failure to maintain trust account records and to follow proper trust accounting procedures rather than misappropriation. Secondly, immediately, and I'm quoting again, immediately upon learning of the amounts of the shortages from the bar's auditor, respondent placed personal funds into his trust account to protect his clients and correct the shortages. Another finding in the plea, the referee's report, no clients were harmed by the shortages. Another, respondent's misconduct was directly related to the disabling effects of mental health disorders from which he suffers: attention deficit hyperactivity disorder and major depressive disorder. Mitigating factors. There were a number of mitigating factors that were agreed to by bar counsel and counsel for Mr. Graham and accepted and incorporated by the referee in the referee's report. 2 of those I'd like to point out at this point. One mitigating factor, the fact that the respondent did not act with a selfish or dishonest motive. A second mitigating factor, the respondent made full and free disclosure and evidenced a cooperative attitude, and then not listed as a mitigating factor, but established in the plea, Mr. Graham did not have any prior disciplinary history. And that, other than the Florida proceedings, remains the case today. We've raised 4 defenses under the rules. First, under 904D, we allege that the misconduct that was the subject of the Florida sanctions order and the underlying facts and circumstances established in the consent judgment show that the misconduct that was the subject of the Florida sanction would have resulted in substantially different discipline if it would have resulted in discipline at all in Texas. Secondly, under 904E, certain aspects of the misconduct that was the subject of the Florida sanction would not be misconduct under the Texas rules, because the Florida rules impose a more comprehensive set of requirements for the maintenance of trust account records.
But Mr. Irwin, would you agree, I don't mean to bicker with you on the fact that some aspects are different, but the substance of $165,000 being out of a trust account would be the same violation both of Texas professional rules and Florida professional rules?
Yes, we're not here today telling you or trying to tell you that none of the misconduct that was the subject of the Florida order would be a violation of the Texas rules. What we are here telling you, and I realize, and I'll admit this right now, this is a technical argument, but this is a technical procedure, because the reciprocal discipline rules contemplate a real short-form hearing where the order from the other jurisdiction is prima facie proof of the violation here, justifying the imposition of sanctions. And it is our position that if there is a material variance between that order in Florida and what would have been subject to disciplinary action in Texas, then that technical process of picking up the Florida order, transporting it to Texas, does not apply, because the rules simply do not contemplate anything other than apples to apples. And in this case, there isn't an apples to apples comparison.
In my understanding, you're saying that from this board's adjudicative perspective, if there were a conclusion that none of the defenses succeeded, there would be no discretion except to impose exactly what was imposed in Florida. Is your view there'd be no discretion to say instead of 3 years, perhaps a shorter period? It's almost ministerial if the defenses fail. If any one or more of the defenses succeed, then this has to be essentially a take-nothing proceeding. Is that the view you're describing, leaving aside whether there could be an evidentiary hearing initiated on a timely basis with full-blown? Is that the view you have, that today is a toggle switch, same or nothing?
I'm going to crawfish a little bit on you, Mr. McKenna. This, as far as I can tell, these rules have not been fleshed out.
Right.
I found one case that considered this proceeding, and it was from 1993 or 1994, the Cushney opinion. So I don't know for sure. But it looks to me as though, yes, if there is a material variance between the discipline imposed in the other jurisdiction and the ability to impose jurisdiction in Texas, then reciprocal discipline does not lie. And we are afforded, I think it's 5 defenses under the rule, 2 of which don't apply on their face. So if we are successful, then I believe the rule says it's not an automatic go away. there is, I think, the ability to do what the board deems appropriate under the facts and circumstances.
So
But
you
I
saying
cannot,
we could have convene a hearing on our own and make our own decision? Is that your?
that's the difficulty in that proposition, Mr. Kittner, is that strikes me as being beyond the function of this body. That is to weigh evidence and decide as an initial matter what sanction would be appropriate for whatever conduct might be deemed to constitute a violation of our rules.
Well, I'm going to put on the record 904, last sentence. If the Board of Disciplinary Appeals determines that one or more of the following defenses have been established, it shall enter such orders as it deems necessary and appropriate.
Yes, sir. And I think that means, as I responded to Mr. McKetta, that this board, as that rule is literally worded, could make whatever orders it deems appropriate. How this board would go about deciding what an appropriate order is on the facts and circumstances, the rule does not help us. The third defense we've alleged is under Rule 1506A of the Rules of Disciplinary Procedure, that a substantial portion of the alleged misconduct that was agreed to and became a finding in the Florida proceeding occurred more than 4 years prior to the time that the petition, in this case, was filed by the commission. And Rule 1506A, as this board knows, reads, no attorney may be disciplined for professional misconduct that occurred more than 4 years before the date on which a grievance alleging the professional misconduct is received by the Chief Disciplinary Counsel.
Mr. Irwin, I have a couple of questions for you.
Yes, ma'am.
I believe I heard you correctly that earlier in your remarks you said that Mr. Graham formerly had an office in Florida. Does that mean he no longer has an office in Florida?
That is in fact true.
Okay.
I don't know that I've covered that yet, but that is in fact true.
And then his current address is in Virginia.
Yes, ma'am.
So is he practicing law in Virginia?
I believe he is not practicing law in Virginia. He is practicing Texas law primarily at this point.
Okay.
He may be admitted pro hoc in proceedings in other jurisdictions other than
Does he
Florida.
maintain an office in Texas?
I'm sorry?
Does he maintain an office in Texas?
My understanding is he does not maintain a physical office in Texas. He does receive mail at an address in Texas.
Okay. I'm looking at just what we've been provided, obviously, but
Right.
it appears to me that there was a substantial delay between the time that the Florida order was entered and this case was filed, correct?
Correct.
Did Mr. Graham ever report to the Texas State Bar that he had been the subject of disciplinary proceedings in Florida?
My understanding is that he did not,
Okay.
and also that our rules do not require self-reporting.
There is an annual certification that happens on, and the current status, as I understand it, shows a certification by Mr. Graham, perhaps it was May 12th, 2014, that does not report any sanctions in other states. Did he have any obligation to do so on his May 12th, 2014 certification?
There is, as I recall, you're referring to
And I'm
government-
not saying that that is a matter that's here before us, but that, it follows on the question and the response.
And my response first is no, that's not really before this board because we have pleaded limitations. There has been no discovery pleading in response.
Right.
81-115, I think, is the number of the government code provision that you're referring to. And it does not, except in sort of a backdoor way, require Texas lawyers to report. What that statute provides, as I recall it, is that the state bar is required to request annually the information required by that statute and to inform Texas lawyers that responding and providing that information is mandatory. I believe that's the way the statute reads.
Is there any support for the position that 4-year statute of limitations would apply in this situation.
Yes, sir, I have an argument for that, and that is based on 1506B of the Rules of Disciplinary Procedure, which says, and I'm going from memory, which at my age is always dangerous, but that rule, as I recall, says that compulsory discipline matters under Part 8 are not subject to the 4-year statute. Given our well-established rules of statutory and rule construction, the choice of the author, the legislature, to not include a provision is construed to be intentional. So when 1506B was drafted excluding compulsory discipline from the operation of the 4-year statute, under the rules of construction, that means that the choice not to include actions under other parts of the rules was intentional rather than an oversight. So the presence of that exclusion implies that the 4-year statute applies to every other action under the rules of disciplinary procedure.
Okay.
Finally, we have alleged under Rule 904C that imposition of a 3-year active suspension at this point when Mr. Graham is less than 2 months away from completing his 3-year suspension imposed in Florida would result in a grave injustice. And we respectfully submit that reciprocal discipline under the facts and circumstances of this case is not appropriate. Thank you.
How do you wish to proceed here? Mr. Berry, do you wish to respond to that? Are we putting on evidence?
My understanding, that was his opening statement. I think it kind of got morphed into a little more than that, but that's fine. I need to put on our case in chief, and then he can put on whatever he wants to, and then I would respond to his affirmative defenses that he has.
Very good, then you may proceed.
Okay, the petition for reciprocal discipline was filed with the Board of Disciplinary Appeals on August 29th, 2014, and the order to show cause was issued by the board on September the 2nd, 2014, requiring the respondent show cause within 30 days why identical discipline should not be imposed in Texas. Proof of service has been on file with the board since September the 26th, 2014. On May 12th, 2011, a petition for emergency suspension was filed in the Supreme Court of Florida in the matter styled the Florida Bar Complainant versus Claude Robert Graham Respondent in TFB cause number 2011-31169-09ECES. On June 29th, 2011, a complaint was filed with the Supreme Court of Florida in the same style number, but with the TBF file number 2011-3455-09E. On November the 8th, 2011, a conditional guilty plea for consent judgment was filed with the Supreme Court of Florida in the same case under case number SC11-1309, TBF file number 2011-3455-09E. The conditional guilty plea for consent judgment established that the respondent violated the following rules regulating the Florida Bar: 4-1.15, 5-1.1b, 5-1.2b, 5-1.2d, and 5-1.2f. On November the 15th, 2011, a report of the referee accepting the consent judgment was filed with the Supreme Court of Florida under cause number SC11-1309, TFB file number 2011-3455-09E. And on December the 22nd, 2011, an order was filed by the Supreme Court of Florida in cause number SC11-1309, lower tribunal number 2011-0 30-455-09E that accepted the report of the referee and suspended the respondent for a period of 3 years. May I approach?
You may.
At this time, the commission would offer petitioner's exhibit number 1, which is a certified copy of the petition for emergency suspension, complaint, conditional guilty plea for consent judgment, and report of the referee accepting the consent judgment in the Florida matter. Exhibit 2 is a certified copy of the order of the Supreme Court of Florida in case number SC 11-1309. And Exhibit 3 is the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court, dated October the 8th, 2014, showing that the respondent is licensed and currently authorized to practice law in Texas. We seek a suspension of 3 years as reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Are you offering exhibits 1, 2, and 3?
I am.
Mr. Irwin, any objections?
None.
They're admitted. Anything
Thank you.
else?
Not at this time.
Thank you. Mr. Irwin.
Mr. Berry, before you get too far away, can you respond to Mr. Irwin's argument on the statute of limitations?
At least 6 months of the conduct that was complained of. There are at least 6 months of the trust account where that are within the statute of limitations, which are within the 4 years, where his trust account showed a shortage of over $150,000 for those 6 months, and those months are within the statute of limitations.
So are you conceding that the 4-year statute of limitations would apply if the facts were applicable here?
I think we could still bring it as a cause. I don't think that. I think it would probably go towards sanctions rather than actual rule violation. I think the statute of limitations, we could get around that for the rule violation because of the shortages that were within that time frame. The other could come in as more evidence of the appropriate sanction to apply.
Well, again, to answer my question, then, if none of the conduct...
Whether it applies to reciprocal discipline
Yes.
issues? It may. I just really can't.
You're being passed a note here.
I'm getting past the note.
The answer may be forthcoming.
Okay. Okay, I think the statute of limitations, I think if we were going to bring it as our own case, I don't think the statute of limitations for reciprocal comes in until we learn about the discipline in the other jurisdiction. That's when
What's the duty of a lawyer to tell the state bar?
the respondent. As Mr. McKenna pointed out, I think the certification that they do every year may come into play. There is not a requirement in Texas for self-reporting. So many times sometimes they do tell us. Sometimes the other jurisdictions send us notice of it or we hear about it other ways. But I think the statute of limitation kicks in when we learn about the
Ms. DeBerry, if I interrupted, I'm sorry.
I tell you what, let's let Mr. Berry sit down and think about these items for a few minutes. I assume you're resting your case at this point.
The case in chief, yes.
And let's let Mr. Irwin address any evidence that he wants to put on, and then we'll have a, if not free-for-all, a robust discussion. Discussion, not an argument. That we can then have all of the evidence in front of us that we want to consider. Mr. Irwin?
Okay.
Thank you. The first thing I was planning to do, and with your indulgence I will do, is request admission of a couple of exhibits. They're going to be numbered oddly because my first 2 exhibits are included in the commission's first exhibit, and I don't see any point in burdening the record with more paper. I have have notified Ms. DeBerry, and I am requesting that this board take judicial or official notice of an excerpt from a document that is the Florida Bar's Florida Standards for Imposing Lawyer Sanctions. And I have previously advised Ms. DeBerry of the specific sections that are included in this excerpt, and I would respectfully request that the board take notice of that document.
And this is marked as exhibit,
Excuse me, yes, exhibit number 3, Respondent's Exhibit 3.
Mr. Berry, do you object to us taking judicial notice of this?
No objections.
All right.
And just being technical, so the board does take notice of that exhibit?
Yes, I'm sorry.
May I approach?
You may.
Secondly, I respectfully request that the board take judicial notice of Respondent's Exhibit number 4, which is excerpts from the State Bar of Texas Board of Directors Policy Manual revised January 2014.
I'm sorry, the Texas?
Yes, Texas.
Any objection to that, Mr. Berry?
No objections.
We will take judicial notice of that. Thank you.
May I approach?
Yes.
Then I also request that the board take notice under Rule of Evidence 202 of the law of the foreign state, that is Florida, and specifically 2 rules under the Florida rules. One is Rule 5-1.2, Trust Accounting Records and Procedures, which probably out of an overabundance of caution I marked as Respondent's Exhibit 5. And then Rule 3-7.6 of the Florida rules, captioned Procedures Before a Referee, which I marked as Respondent's Exhibit 6. And I respectfully request that the board take notice of those 2 rules under Rule 202 of the Rules of Evidence, and I have copies here to make the board aware of the substance of those rules as required by the rule. If I may approach, I'll hand those to you.
You may. Any objection to that, Mr.
No
Berry?
objections.
We will take judicial notice of the matters contained in Exhibits 5 and 6.
And although I believe Ms. DeBerry has effectively admitted or stipulated, I do want the record to be clear and would ask for perhaps belt and suspenders basis that the board officially notice that its file reflects that the commission filed its petition in this matter on August the 29th of 2014.
No objections.
And that is reflected in our file. We will, to the extent necessary, take judicial notice of that.
Thank you very much, and with that, I will call Mr. Graham for a brief bit of testimony. State your name for the record, please, sir.
Claude Robert Graham.
How old a man are you?
I am 64.
What's your date of birth?
January 5th, 1950,
Where do you currently reside?
in Virginia, Chesapeake, Virginia,
What do you consider to be your domicile?
Texas.
Why?
Well, I was born and raised here. I own property here. I have an interest in a company which I call Graham Cattle Company, which has started in the 90s, which has land, cattle, minerals, etc. And I'm domiciled in Texas.
Why is it you wound up living, at least temporarily, in Virginia?
Well, while I was in Florida going to law school, I met this very wonderful young lawyer, and we ended up getting married. She's a much better lawyer than I have, or else I'd have her in Texas, but she won. So she's from Virginia. And her parents were getting elderly, and so we moved up there and bought a house in 2008.
Are you involved in non-legal businesses that are owned by your father-in-law?
I am.
And are those businesses located in Virginia?
Yes, they are.
It's my understanding you're licensed to practice law in both Texas and Florida at present, correct?
Well, I'm ineligible in Florida, but yes, I am licensed in both states.
All right, you're currently suspended in Florida.
That's correct.
When does that suspension end as you understand the order?
December 22nd, 2014.
During the term of your active suspension in Florida from, I think it's December 22nd of 2011 to the present, have there been any compliance problems that you've been made aware of? Anybody complain that you're not doing what you're supposed to do under the order?
No.
Where did you go to law school?
I went to law school in Florida, in Jacksonville, Florida, Florida Coastal School of Law.
When did you graduate from law school?
May of 2001.
When were you licensed to practice law in Florida?
In September of 2002.
When were you licensed to practice law in Texas?
In September of 2008.
Oh, I'm sorry, what year?
2008.
Thank you.
Obviously, since you and I are about the same age and you weren't licensed until 2002, you must have done something before going to law school.
That is correct. As stated previously, I was in the land and cattle business, and after graduating from college, I got into the oil business like every good Texan does in the 70s, right after the oil embargo and the price of oil shot up to $40 a barrel. And that worked real well for about 10 or 12 years till the oil got back down to about $8.50 a barrel. And my business in Texas was I had a couple of drilling rigs and some workover rigs, as well as did some operating of stripper leases. In fact, I was partners with my brother, who is a geologist, who is now assistant director of District 2 there in San Antonio, covering 43 counties.
Okay. Did you ever have a law office in the state of Florida?
Yes, I did.
Do you still?
No, I don't.
Why not?
Because as part of my agreement with the state of Florida on my suspension, I was to cease all activities. I shut down my office immediately. I closed, telephone lines, websites, let my staff go, and moved. Well, actually, I'd already moved, but
Okay.
not doing any more business.
Let's focus now on the Florida disciplinary proceeding. There first was what was referred to as an emergency suspension, correct?
Actually, there was a little more to it before that. There was a check that did not clear the trust account, and I received a letter from the Florida Bar. And I was assigned a Florida Bar attorney. His name was Ken Burke, very nice gentleman. And he allowed me to work with him for about 60 days to try to get everything together, get paperwork to him and such. And then when I realized the magnitude of where I was, and he gave me notice that he wanted to take my deposition. I said, well, I probably need a lawyer for that. And he suggested one, and I took that lawyer to sit for my deposition and represent me.
So in the process that led to the referee's report and ultimately the Florida Supreme Court sanctions order, you had your deposition taken by the
Yes, sir.
Florida Bar.
Yes, sir.
How long do you recall that deposition lasting approximately?
2 to 3 hours. Is very comprehensive.
During the course of that proceeding, did you or your lawyer provide medical records to the bar?
Yes.
During the course of that proceeding, did you or your lawyer provide an audit report prepared by an auditor retained by your lawyer or by you?
Yes.
All right. Now, as you heard me refer in the opening, and as you of course know, the consent judgment that now is a part of the petitioner's Exhibit 1 refers to the misconduct for which you were found to have violated the Florida rules to, and I don't recall the precise words, but basically result from the ADHD and major depressive disorders. Since the time of your suspension in Florida, have you been receiving treatment for both of the, or either of those issues?
Yes. Actually, I started treatment before the problems with the Florida Bar, and have continued them. My last visit was in August of 2014, and I have another one coming up here as soon as we get finished with this matter.
All right, from whom are you receiving that treatment?
From a Dr. Reed, David Reed in Chesapeake. He's a psychiatrist.
Do you take any medications on a continuing basis at present?
Yes, I do. I take Adderall 20 milligrams in the morning and Lexapro 20 milligrams in the evening,
How often do you see Dr. Reed?
every 90 days.
Is the Florida matter, that is the emergency suspension that we discussed and then the 3-year active suspension, the only lawyer discipline sanctions that have ever been imposed against you?
Yes.
What is your understanding of the period of time that the misconduct that is the subject of the Florida Supreme Court's order covered?
Covered from March of 2010 to February 28th of 2011.
Do you know whether your 3-year suspension in Florida is disclosed on the Florida Bar's online profile for you?
Yes, it is.
I pass the witness.
Mr. Barry, do you have any questions?
I have just a couple of questions. I think, and it may have been your attorney's representation, that you maintained a mailing address in Texas, is that correct?
It's kind of try to explain like this was I don't do any legal work in Texas without associating with other lawyers. And part of the reason this is because of my short tenure as a lawyer. I've only been doing it for 12 or 13 years. And so it's a fair, profit for my clients. And most of my law stuff that I do is oil and gas, which I have a good background in. But yes, I do have the address of which I get mailings from courts at any lawyer that I'm associated with on particular files, and that happens to be Peter E. Ferraro here in Austin.
But you don't disclose that in your annual certification to the State Bar, did you?
No, because it's not my office.
But you don't have that as any alternative mailing address or anything else with the State Bar, is that correct?
That's correct.
Okay, so the only address you have listed with the State Bar is in Virginia.
That is correct.
Okay. You testified that you see a psychiatrist every 90 days. Do you receive any psychotherapists from anyone else, psychotherapy or anything else?
No, just from Dr. Reed.
So that's primarily for medication?
It's medication, and he does an interview with me every time. It's about an hour of visitation.
So there's no ongoing psychotherapy, anything like that?
I'm not sure what you mean by psychotherapy, but he talks to me about, how my work is going. Am I having any problems with the bar? Because he was involved in the Florida and testified with the Florida Bar as to my condition, and we visit about things that bother me and things that I have going to cause stress in my life.
So, how long have you been? When did you start seeing him?
I saw him. I was a referral from Dr. Katz, who was a psychologist that I saw who was in Chesapeake, who thought I needed a little more help, and to began seeing Dr. Reed in, I believe, April of 2010.
And have you always seen him every 90 days?
Yes, I have.
No, never more frequently than that?
No?
Okay, thank you. That's all I have.
Any other questions, Mr. Irwin?
I do not, sir.
Any questions from the members of the board?
I have one. Mr. Graham, is there any requirement under Florida disciplinary procedures that if you are or receive a sanction that you notify other jurisdictions where you practice?
No, not that I know of.
Did you give any consideration to notifying the state of Texas about your discipline in Florida?
No.
During the time that you have been suspended in Florida, have you, and I don't know what this means, but have you practiced law in Texas?
Have I practiced law in Texas?
Since you got suspended in the
Yes,
3 years?
I practiced law in Texas.
And can you give us some idea of the magnitude of that in terms of
I,
hours or?
Certainly. I represent mineral owners against oil companies, and a lot of it's because of my background in the oil and gas business. And because I don't have as much experience in the litigation arena, I associate with good litigators, like Mr. Ferraro here and others across the state. And this is stuff we do in other states as well, pro hoc vici. But yes, I do practice law here. I do seminars to mineral owners. A lot of it is to protect their rights, and such as pipeline easements, things like that. They're generally single-page documents. But when I'm finished with them, it gives them all the rights that they should have knowledge about. And of course, we've had the big ruling here, which was the Marshall ruling in 2013, which is giving 25 years statute of limitations adverse possession to oil companies on the zones they're producing. And there's very, very few lawyers that are doing that and giving that information to these mineral owners. Because like our Austin chalk wells that we're having.
Let me stop you there. Is it fair to say that your main practice is oil and gas litigation?
Yes, sir.
And again, can you give me some idea of the magnitude of it, either in terms of hours or?
Probably about 20 hours a week, 25 hours a week, research, evaluations. I'll start in on an evaluation of an oil lease, go back to the history of it, get all the monthly production reports from the Railroad Commission as well, compare that, to the oil and gas lease, see where the mistakes have been made that would possibly give us and give the landowners an opportunity to get some of the Eagle Ford money that they didn't get.
How many cases do you think you're handling right now?
15 or 20.
And is your name on all these pleadings with Mr. Ferrero?
If there's a lawsuit filed, yes.
You do most of your work, your actual work in Virginia, though, is that correct?
Except for depositions when I come down here to depose their experts, et cetera, because of my background in the oil and gas business, yes.
You said
I
you
travel a lot.
You said you own property in Texas. Where's the property that you owned?
Well, at one time I had it in Duval County, Webb County, let's see, Jim Wells County, Nueces County, and Goliad County. And at this point in time, I've sold off several of the tracts, and I just now have a couple ranches left in Goliad County.
You ever have any property in Gonzales County?
No, but I do a lot of practice in Gonzales County.
Mr. Graham, when you received your disbarment from Florida, were you aware of the reciprocal discipline rules of Texas at that time?
I was made aware of it when I got served September 9th, 2014. I've never heard of it before.
You've never disclosed to the Texas attorneys that you associated with that you had been disbarred in Florida?
Not disbarred, suspended.
I'm sorry,
But yes,
suspended.
Mr. Ferraro and John Eaton and other lawyers that I've done business with here are aware of that.
Sir, do you maintain a trust account?
No, I do not.
How do you handle fees that come in? Are they deposited into a general account?
They come into the other lawyers that I work with.
And then how do you get paid?
From the other lawyers.
I noticed on your, the proof of service that you were served in San Antonio, is that correct?
That's correct. It's my son's home.
Your son's home?
Yes.
Where is the office of Mr. Ferrero?
Here in Austin. It's on 10th Street.
Okay.
Mr. Graham, you go ahead.
Well, when you have clients, are they your clients in the sense that you had the first contact with them, or does Mr. Ferrero associate you? How does that?
It could go either way. If it's a client that's come to me by word of mouth from a previous client, like in Gonzales County, where we have a lot of clients.
Well, with the clients that you have engagement letters with any of them?
Yeah, I have engagement letters. We'll have my name and Mr. Ferraro's or whoever the lawyer that's on it.
Thank you.
Mr. Graham, first, the attention deficit and hyperactivity and depression, have they ever been at such severe a level as to result in your inability to practice?
I don't know how to answer that, but I will tell you what got me to go to the physicians back in early 2010, late 2009. I was concerned I was coming down with Alzheimer's. I couldn't remember stuff, and so that's when they diagnosed me with that. I was getting very concerned. I mean, I was just in my early 60s. I didn't think that was quite the time to be having that come upon me, and that's But when Dr. Reed explained to me, it really made a lot of sense, you know, and when I was taught, living here in Texas, in high school, we were taught to speed read, you know, and I still have a very difficult time because as a lawyer, you need to read for content. So when I took the bar, you know, I have a ruler, and I go down every line by line to be able to get the concept of it, because I can read a book in a day just by going fast. But that, and then the memory issues, then that was, of course, the depression, which I didn't really realize I had, but he was able to point it out to me.
So in 2008 or 2009, you think you may have had an inability to practice due to those conditions?
I wouldn't say an inability to practice. What I would say is I had an issue with memory, and the way it was been explained to me is that I'll have a flood of information coming in, and I have a hard time distinguishing priorities on what I need to do. Now, I do it myself, like with my clients. I spend an inordinate amount of time because I'm very concerned about it. When I was a younger man in business, and, you know, of course, I was 50 when I took the bar, 51, I believe. 10, 15, 20 minutes would be a time. But nowadays, when I'm with a client, it's an hour, 2 hours, because I want to make sure, and I know my limitations, that what I'm getting and what I'm doing, and then I do, of course, a lot of research to make sure that the advice that I'm giving them is good advice. And then, of course, I've also, you know, interspersed that with the, you know, the co-counseling, you know, with other lawyers that are very, you know, they're 30, 40, 50, I won't say 50-year practitioners, but they've got a lot of experience.
Are you licensed in Virginia?
I was licensed in Virginia as a corporate attorney in 2009, and gave it up in 2011 when I was made vice president of these certain quote-unquote companies that my father-in-law owns. My wife is corporate vice president.
Since 2011, you've not been a member of the bar in Virginia?
Virginia, no.
Okay. I want to ask some questions that relate to the topic of limitations. That's kind of where my chronology is coming from. My understanding is that the highest out-of-order dollar amount of your balance account was about $165,000. And as I understand the complaint that was filed in Florida, that was as of October 31, 2010. Does that sound accurate to you?
No, it doesn't. And let me explain.
Sure.
When I hired, at the suggestion of the bar, I hired a auditor, CPA, who's very familiar with bar. He was an ex-bar auditor. And he went through all of this stuff. And in the evidence that was submitted, you'll see two deposits, one for $92,000, and then a subsequent one for, I think, for $39,000. And those figures are what they came up with, not the bar. And that was the only monies I ever put back in because the accounts were okay then. And my understanding in reviewing the the tabulation that the bar, Mr. Pearson, the bar auditor, did, he was trying to fill in the blanks. And he was using an Excel sheet and taking the information I had given him, which was very poor information. Mm-hmm. And that's what he came up with, but that was not the true amount.
And what was your understanding the highest true amount of discrepancy between the balance shown and the amount in the bank?
It would be the balance of the deposits that I made.
The 95,000?
90, I think a 92 and a 39.
As of the 92,000, as of what date was that discrepancy in the account?
I don't remember to be on the deposit slip.
It would be at about the time that you put in the amount?
Yes, exactly. As soon as they told me, I made the deposit the same day.
And that was after October 31st, 2010?
I presume so. I don't remember that date.
So the highest discrepancy that you believe occurred was within 4 years, going back in time, of the August 29th, 2014 petition?
I don't know. I can't answer that without looking.
Right. If you have that information, I'd be happy for you to supplement that. But I want to understand whether the peak failure to true up
Sure.
occurred within 4 years, just to better appreciate where the limitations issue ought to be in these facts. You did have a trust account in Florida.
Yes.
Have you ever had a trust account in Texas?
No.
And what's missing is an understanding of how the balances got so out of order. Do you want to give us a few sentences to help us
Certainly,
understand?
Best my understanding was, and I think it reflects on what Mr. Pearson showed, and then there should be a second set, which is what, you know, my CPA came up with, that is not in the official records, but I do have a copy of it, probably in Virginia. But it was a repetitive transfer from the trust account to the operating account in Florida, same bank, Wachovia, for attorney fees. And what it would be, like I would do it, 3 of them in 1 week on the same file. And these were all telephonic transfers. In other words, it was not writing a check to transfer it over. And I was doing them out of Virginia for Florida. Just, you know, not remembering that I had done it.
After the $92,000 true-up, how did it come about that a later $31,000 or $32,000 true-up also was necessary?
Here again, I'm not exactly sure, but I would say that these were figures that I was given by my CPA and my bookkeeper at points in time when they would do this. And I think that they had done it to a certain point, and then they said, here's what you need to put in. And I put it in that same day. And then they'd come further down, then here's what we're finished up with, and there's still another $39,000.
The essence is that the trust account would receive settlement proceeds, and then you'd make disbursement from that.
That's correct.
And the intention was that you would take typically a 1/3 fee, I gather, from the ledger and expenses for your account and the balance for a client.
What the client was due, they would get paid, I would get paid. A lot of the excess money in there was for medical fees owed, and generally if the medical fees were of a large enough sum, we would sit back and, with this was permission with the client, let them sit to where we get a better deduction, or we would have a motion for equitable distribution in front of a judge.
And what would be a circumstance where you would inadvertently take attorney's fees a second time from a particular settlement?
Could you repeat that again, please?
Sure. I'd understood you to say that what you gather had happened is that you had unintentionally taken attorney's fees out repeatedly
Per file.
rather than a single occasion per file. Have I understood you correctly?
Correct.
And I was just trying to understand how would that happen?
Doing it by memory. I thought that I hadn't done it, and then I would redo it.
The internal Florida procedure that was shared with us, as we've taken judicial notice of, says that where there's negligence in dealing with client property, but no actual or potential injury, it actually says little or no actual or potential injury to a client, that the typical discipline is admonishment rather than public reprimand and rather than suspension. You agreed to a suspension instead of an admonishment. You had counsel at the time.
Yes, I did.
And what were the circumstances that led you to agree to a suspension even though the internal guidelines that are shared with us from Florida would seem to indicate an admonishment?
Well, first of all, I was offered a disbarment, and I thought that the suspension was just a wonderful deal,
Right.
rather than disbarment. And then also at this time, 2009, 10, 11, the Florida bar was disbarring a lot of Florida lawyers, most of them that were real estate lawyers. We had this huge growth up into 2006 where properties were doubling in 2 years, which we all know is not a sustainable growth. And so lawyers in Florida is probably, I say lawyers, Florida is probably only 30% attorney title companies. The rest are corporate. And what my wife did, she was with the underwriter for Virginia, state of Florida, and U.S. Virgin Island for lawyers title and Commonwealth title, two of the oldest title companies. And so what they were seeing is all this money missing out of these settlements, but weren't listed on the HUD statements. And so there was, the bar was very busy during that time period. And they were disbarring a lot of lawyers.
I've had read colloquially that was so.
Right.
What would be the burden on you, if there is one, of your undertaking for your practice in Texas never to receive client funds? In other words, not to have trust funds or responsibilities for trust accounts.
So based on my past, and made a pact with myself that if I gotten through this, I don't need a trust account. I don't handle any funds.
Do you plan to resume practice in Florida?
No. I hadn't planned to practice there in the first place. At this supervening event, the wife.
Thank you.
Mr. Graham, just a couple of follow-up questions. Am I correct that regardless of the reason that you received money to which you were not entitled?
Yes, sir.
And some of the money might have been earmarked to pay medical providers?
Yes, sir.
And some of the money might have been money that should have gone to clients?
No, not the clients that I know of, but could have been, yes. I don't know.
Are you required when you do a disbursement of proceeds from a settlement to give some sort of settlement sheet?
I do a settlement sheet. It will give the attorney fees, the date, time, plaintiff, defendant's names, of course, it lists the costs. And then generally what we put on the medical cost part, not to be distributed and to be reduced.
And the amount
Client
of
signs.
fees that you could take out of the trust would be set forth on the settlement sheet?
Right.
But you were taking additional fees or taking money that should have been earmarked for payment of medical bills? Is that correct?
Some earmarked for something else, yes.
Mr. Graham, what's your understanding of how the state bar learned of the Florida activity?
There was a check that went back, and the bar was notified from the bank.
No, that's in Florida, right?
Right in Florida.
That was, they had a rule where a bounced trust account check gives notice.
Right.
But how did Texas learn?
I have no idea.
In the course of these proceedings, you have not come to learn how Texas learned of what happened in Florida?
I would love to know.
Then the next question would be along the lines of, assuming Texas State Bar CDC learned earlier than they did, do you understand that they likely would have brought these reciprocity proceedings earlier in time?
I do know that now, yes, sir.
And that, do you have any reason to doubt factually that they have brought this as soon as they learned?
I presume so.
How do you, on the field of what's fair and appropriate, are you asking for no reciprocal discipline in Texas, or that it only run until you get finished in a couple of months in Florida, or what is your position on that?
Well, I'm not too sure how to answer that. My lawyer may not be happy about it, but I had made an offer to the board, not the board, but the CDC.
I'm going to object.
Yeah, I'm not trying to get into settlement talk.
I would
So objection sustained.
Thank you.
I feel that it would be an injustice for me to suffer 3 more years of suspension in Texas. Okay? I feel that I provide a service to my clients here, a very good service. I mean, I can give you hundreds of letters of just thank my clients average anywhere from 60 to, I got one that's 92 years old. And these are people that, most of them out of the Joliet, Gonzales, DeWitt County, where the Eagle Ford is, and most of them missed out on the early leasing because their leases were held by Shell Production. So the oil companies got the benefit of that $3,000 to $5,000 an acre, which we've never seen before in Texas before. And like I said, I was in the oil business for 16 years. Highest bonus monies in those days was $160 an acre. Then all of a sudden, you know, boom, we have the Eagle Ford. But what I've been able to do, and I've, knock on wood, have been very successful at it, is getting these deep rights released and these mineral owners being compensated for it.
Okay, but my question had to do with whether, I understand you've told me that you don't think 3 years would be fair starting now. What do you think would be fair and appropriate?
I think a probation, based on what I've been told by my attorney, that the Texas rules would have provided possibly 4 or even less because of the mitigating circumstances here in Texas for the same sort of, mismanagement, negligence of the trust account.
Thank you.
Mr. Graham, I have, Mr. Oh, it is. I'm sorry. I just have one question for you. When you updated your profile online with the State Bar of Texas, why did you not include the suspension in Florida online?
I think I was trying to figure out why I updated it because my attorney asked me why. I had a toll-free number on it, and to Virginia, when I changed phone companies then in May, it was no longer valid. I have a different one. So I just put the regular Virginia phone number in there, 757-488-1188. I didn't look at anything else but the phone number.
Okay, thank you.
Other questions?
I have one follow-up question, if I may.
All right.
You had testified that you made distributions from your trust account to your operating account. The trust journal that was provided shows some transfer to the Graham Cattle Company.
Those would be deposits.
Those are all, no, there's some that are, looks like there's some that were not deposits, where the balance actually went down.
Barry, could you tell us what you're referring to?
Yes, in the
Page 5, ledger report.
page 6566, 64, it's in the information from Florida. It's called the C. Robert Graham P.L. Trust Journal as of February 28, 2011.
Thank you.
And on several pages there are, let's see if I can direct your attention, if I can, to, I think it starts, the numbers are on the bottom of the page. It's on page 64, starting 9/2010. There were some debits to the cattle company.
If I could see it, I might
Certainly.
explain it, but generally, I did work for Graham Cattle Company and charged for it hourly. I don't remember writing any checks to Graham Cattle Company.
But wouldn't you agree, so the work you did was for Graham Cattle Company, is that what you're saying?
Right.
Okay.
The only things I can remember, there was a land transaction where I bought a piece of neighbor property that came up from funds from Graham Cattle Company. And there were some royalty sales that I did for Graham Cattle Company.
May I approach? And there's some, they're on different pages.
Okay, on 9/1/10, that's a transfer to, and it doesn't say who it's to, but it would reflect from Graham Cattle Company.
That was for $5,000.
2920 it shows here.
Looking at 9-1.
9-1. 2920. Now what 5,000 is a Geico
That's
deposit?
it says, but the 2920 is a debit, it's not a credit.
I don't know. Let's see what else we got down here.
You're right, that is a debit, 29.
See, what it says transfer to, I'm presuming that is to one of my accounts in the trust journal, right? See, I don't know what the redactions are. But
Well, it's just the last 4 digits of the account number, but it says what account it is, and it's to Graham Cattle Company is what the distribution's to.
I'm not sure about that. I couldn't testify to that. I can testify that, that Graham Cattle Company was a client, although it's a client that I have an interest in, okay? But I didn't work for them, and it could be funds that I recovered for them or whatever. Because every dollar, Graham Cattle Company is a limited partnership, and of course they have a CPA that takes care of it in San Antonio, and I certainly could get all those figures.
But there are numerous distributions to them, so I'm wondering what those were for.
Well, as I testified, I don't know. And I don't know if this ledger here is the ledger that we did, or that, you know, our auditor did, which the bar has agreed to, or is it the one that Mr. Pearson did when he was trying to plug in the blanks?
Any other questions, Mr. Berry?
That's all I have.
Other questions from the board? I have one question, Mr. Graham.
Yes.
After the suspension in Florida went into effect, were you continuing to practice law in Texas?
In the suspension there, in Florida, yes, I was.
So even during the time of the suspension in Florida, you were still practicing over here?
In 2010, no. 2011, 12, 13, and 14, yes.
All right. Thank you. Anything else for this witness?
Not for me.
You may step down, Mr. Graham. Thank you.
Thank you.
Have any further evidence, Mr. Irwin?
We rest.
We have no further evidence. I'll be glad to argue the points that we started before and some of the other things brought up today.
So you both close, I take it? Mr. Berry? I think it's time for the discussion.
Take these, I guess, one at a time. The earliest we can find out, and I'm not even sure how we learned of the suspension in Florida, was on August the 11th, 2014.
How did you learn of it?
I don't know. I have a telephone memo that someone called. I'm not even sure they told us who they were. It informed us of the suspension and gave us some basic information about it so we could follow up. And sometimes they are anonymous, but that's the note that I have on it, is when we first found out about it. As far as the statute of limitations, if you go to the definition of misconduct in the rules, Rule 1.06, what professional misconduct includes. W2, attorney conduct that occurs in another state or the District of Columbia and results in disciplining of attorney in that other jurisdiction if the conduct is professional misconduct under the Texas Rules of Professional Conduct. So the act of having a judgment in the other state is what constitutes professional misconduct for reciprocal, and that's when the statute of limitations would kick in. As far as whether the 4-year statute applies, it would be when that judgment is entered in that state. And does that answer the question?
That answers the question?
I'll ask earlier. Okay.
Thank you.
And then I think one of the other things that was brought up is whether this board has the ability, and I think you all have already considered that, to modify the judgment, and it's your discretion kicks in if you find that one of the defenses raised would be applicable.
So your position would be that we could do any range from probation to 3 years, is that correct?
I think it's the board's discretion.
Well, that's what I'm asking you, so you
I don't
wouldn't-
think it's, I think the discipline he received in Florida was appropriate. I think it's appropriate reciprocal discipline here. But I do think that if you all find that he has proven one of the defenses, I think you all have that discretion, yes.
Do you agree with that?
If I understood, I'm kind of not hearing everything Ms. DeBerry is saying, but if I heard her correctly, I believe the board does have discretion once it finds that we have established one of the defenses, as Mr. Johnson pointed out, the last part of that rule. And I think that could be whatever is available under the rules in terms of the form of discipline.
Now I will address some of the other things he's brought up. He talks about the mitigating factors that are cited in the judgment. What Mr. Irwin has totally neglected and ignored are the aggravating factors, which was a pattern of misconduct and multiple offenses. The multiple transfers from the trust to the operating account to Trust Graham Cattle Company, from trust to Graham Cattle, and the amount, I think, of shortages in the account. For like 9 months, it was over $150,000, or about $150,000 consistently. I think that's serious misconduct, and it's not that we don't have to have the exact rule that Florida has. The fact that it's misconduct in Florida and it's misconduct in this state makes it a reciprocal disciplinary matter, and I don't think there's any question that there were trust account violations, that there were funds missing from the trust account, and that constitutes misconduct here.
Mr. Berry, in looking at Respondent's Exhibit 3, the Florida standards for imposing lawyer sanctions, it seems that they have very specific guidelines for sanctions. Disbarment, if the lawyer has intentionally or knowingly converted client property, and on down to a public reprimand or admonishment. Does Texas have any comparable rule?
Texas does not. Many states do use the ADA, has standards. Many states have their own standards. Texas does not have standards. It's taken on a case-by-case basis. We have specific factors that are considered in imposing sanctions, and that's what the panels or the court has discretion then based on those individual on those factors and everything that's presented. I think in this case they also had some other case law that they cited in their determination of how to impose those sanctions. And for that reason, Mr. Irwin, has talked about several cases in Texas. That's a very small sampling of the cases. He's trying to say we wouldn't do the same discipline here. I don't think that's true. I think that's just pure speculation. There's no way we would know if this were in front of a panel what would have happened. Cafiera was disbarred for similar conduct. This board is considering one of the cases that was passed today was I think a New Jersey case, Livingston, where it was almost identical facts to this, and the attorney was disbarred there. Jason Galvez, and some of these are cases that we've had in our office, had a 2-year partially probated with 1 year active for deficits in his trust account. Gordon Harden received a 10-year partially probated suspension with a 1.5 years active. So there are just too many factors to be considered when you look at a case in determining what would be appropriate. So I don't think I think the purpose behind reciprocal discipline is that the jurisdiction that imposes the discipline is in the best position to determine what the attorney did that was incorrect and what that punishment should be. I think the amount of shortages in his trust account certainly warrant a severe sanction. Mr. Irwin also tries to say there's grave injustice if he has to undergo a 3-year suspension here. I don't see that. He's been able to practice the whole time he was suspended in Florida here, and within 2 months, if this board enters a active suspension against him, he'll be able to go back and practice in Florida. So I don't see any grave injustice in that matter. The fact is, he pled guilty in Florida. He accepted the sanction there. I think it's an appropriate sanction for our purposes in Texas. Are there any questions?
Question, Mr. Berry?
And that's different from Livingston's case, isn't it? Because your allegations are he knowingly misappropriated client's property, and he also didn't comply and didn't cooperate with disciplinary authorities in New Jersey.
I'm not real familiar with that case, I'll be real honest with you, but I think he negligently did it. I could be wrong about that.
Well, it says he knowingly misappropriated funds. So.
Okay, so there are some differences.
Ms. Stevens has been deprived of the opportunity to talk today. We can always answer that question herself.
So we respectfully request that the board enter a judgment of 3-year active suspension as reciprocal discipline.
Thank you. Mr. Irwin?
I'm not going to follow through on my threat to tell you all 15 of the factors that I think are worth considering in this case. They are apparent in the plea and in the referee's report. The mitigating factors, the fact that there was not an intentional misappropriation. So I'm going to skip that in the interest of time, but I do respectfully request that the board really focus in on what it was that formed the basis of discipline in Florida. And following up on one of Mr. McKetta's questions about why suspension in Florida and not an admonishment or a public reprimand, if you look at Rule 4.12, which is cited in the referee's report and is part of respondent's exhibit that I cleverly left the number off of, but it's the Florida standards.
Three.
Thank you. That provision says suspension is appropriate when a lawyer knows or should know that he is dealing improperly with client property and causes injury or potential injury to a client. And the first sentence in the comment underneath the rule says suspension should be reserved for lawyers who engage in misconduct that does not amount to misappropriation or conversion. Why, as I understand it, the Florida sanction wound up suspension is because the next lower level of discipline under 4.13 is simple negligence. And the finding that you'll see in the referee's report and the consent judgment is gross negligence. So that's why, as I understand the rules, it ended up with a suspension. And as the point was made a minute ago, I think that's a very significant point, because Florida does have these standards. The referee referred to and followed these standards in agreeing to and recommending the 3-year active suspension. Texas does not have that. And as I pled in...
Mr. Arnold, I'm sorry, forgive me for interrupting. Didn't Mr. Graham say that one of the bases for resulting in the suspension was because the Florida bar was seeking disbarment? Did I not hear him say that?
I think he said that was on the table.
Okay.
And that is before, I don't know what stage it was. That's not in the record.
Yeah,
Well,
if
let me-
disbarment, if they had successfully shown intentional or knowingly, then disbarment was indicated, so that's the litigation risk, I presume, that was avoided by.
Well, and it's a follow-up to that. Ms. Berry said that shouldn't we just defer to the state that actually went through the process and defer to them because they're in the best position to make that determination, which I guess in essence is the basis for reciprocal discipline. We don't have many where the arguments are being made as you're making, but if disbarment was on the table, it was a discussion, it was in effect a plea bargain, if you say that, doesn't that suggest that the conduct was more serious than simply what you're trying to tell us today?
No, I don't believe that's the case. And to support my belief, I'd refer you to Florida Rule 3-7.6, which is one of the exhibits that we admitted today, and specifically subparagraphs M and O4. What M says is that the referee's findings of fact with respect to the misconduct enjoy the same presumption under Florida law of correctness as the judgment of the trier of fact in a civil proceeding. And there was discovery in this case, and there were documents exchanged. This was, as I understand it, and as the record reveals, was not a simple sit down at the table and come up with some agreement. Then 3-7.604 provides that the procedure is the same for a plea of guilty as for any other referee proceeding. So when you put those two rules together, I think you have more than simply a deal drawn together out of discussions between lawyers. This was a deal, it was agreed to, but it had to pass muster with the referee, and then the referee's report had to pass muster with the Florida Supreme Court. So that's the basis for my answer to your questions.
Okay, and then as a follow-up to that, what is your response to its sheer speculation as to what a grievance committee here would have done?
I think that is true, and I considered presenting or attempting to present an expert witness to say what discipline would have been, and I concluded that that would be futile because you all would say, we don't need to be told about what we regularly deal with. But I think that also is largely not relevant to the decision because the defense that we're relying on is, in that respect, is that the misconduct established in the other jurisdiction warrants substantially different discipline in this state, not specifically what that discipline would have been had there been a proceeding in this state, but substantially different. And when you put the Florida standards for meting out disciplinary sanctions, which are very specific, together with what Texas provides, I think it is a very solid conclusion that had Mr. Graham been brought before an evidentiary panel in Texas with these same facts, he would not have been suspended. And in fact, I don't remember if this is in my pleading, but if you look at the State Board Policy Manual and the criteria in section 6.09.01 for eligibility to participate in grievance referral program, which, as the board knows, successfully completed results in dismissal and no discipline, dismissal of the complaint and no discipline. If you go through the factors from A through H of 6.09.01, he satisfies those factors.
He does, if you don't look at the initial 3 lines at the top that says minor misconduct cases. Does the word minor leave some judgment on whether $160,000, whether average of $3,000 from 50 files is a pattern that's not minor? That you presuppose that we've characterized it as minor, and then we look to those factors.
I would disagree with you as to my logic on that point, Mr. McKenna. I agree with you that it does, you know, plain as the nose on my face, say minor misconduct. And I'm not going to stand here and tell you that the failures to comply with trust account procedures that are in the record of this case are minor. That's not my argument. My argument is, yeah, it says minor, but then when the rule or the policy establishes eligibility, that word minor is not in there. The factors it lays out, which I assume establish what constitutes a minor violation for this purpose and this purpose only, are those factors A through H. Now, if I'm wrong about that, then that argument fails, and he would not have been eligible for GRP. And plus, you know, the commission might not have recommended GRP. But my point is, this is the base procedure, and it appears to me, depending on your interpretation of the language of the policy, that he qualified. And then I cited 3 judicial opinions, and I agree, you can find sanctions cases that result in sanctions all over the board. But these 3 opinions that I cited in paragraph 5 of our response on Wutika, if I'm pronouncing the gentleman's name correctly, Cluck and Fry, all involved at least a Rule 1.14 violation for mishandling trust funds. And they also involved other issues. And on Wutika resulted in a 3-year fully probated suspension. Cluck resulted in a 2-year fully probated suspension. Fry resulted in agreed public reprimand. When you put together the mitigating factors, the absence of a corrupt intent or motive, and all of the other, particularly the causation resulting from the ADHD and depression, those are the sorts of issues that I respectfully submit would have been perfect for GRP, because GRP is supposed to take a lawyer who's not functioning as he or she should, design a program to get them to where they need to be, and hopefully make them a productive member of the bar in the future who is not going to repeat that sort of conduct. So that, I think, is why I responded to your question that what the specific result would have been if there had been a Texas evidentiary panel proceeding, while intellectually interesting, something I'd like to know, doesn't drive your decision in this case, in my opinion.
Yet the affirmative, these are essentially affirmative defenses, or I would think of them as affirmative defenses, that the burden that is imposed on your case, not your problem, but your burden is evidence by clear and convincing.
Yes, sir, I agree.
And so we need to look at the evidence that's been presented through that prism of what we all collectively think is clear and convincing evidence. Correct?
Yes, sir, and I agree with that. And I would add to that, that in that regard, it is significant that the commission incorporated verbatim the consent judgment, the referee's report to the Supreme Court of Florida, along with other pleadings from that case. When someone pleads and incorporates a document attached to the pleading, not in the alternative, but pleads and incorporates the pleading, that is a judicial admission. And I have cases I'll be happy to leave with you that establishes that that is the case. So here, the state of the record is that the commission has judicially admitted all of those factors on which we're relying. And I submit to you that that is well above clear and convincing. That's a judicial admission that is binding on the commission.
Well, I speculate they may disagree with that it's a judicial admission of the sort that you have, and I appreciate your argument on that. And certainly, they incorporated it. And there's no doubt about that. But don't we still have to cross the bridge between what those documents say and what Texas might have done with those facts? And isn't that bridge over if I'll carry the metaphor longer, over a river of
troubled waters
or speculation?
No, I don't think so. And I don't think so because I want to go back to something I said in my opening. I'm making technical arguments, clearly. But this, again, is a very technical proceeding. And in order for this short-form discipline to be imposed, those technicalities are important. And the commission has the burden to comply with them in order, I got that backwards. The commission introduces the sanctions order, then we have the burden to show as an affirmative defense that one of those 5 situations applies such that the judgment the commission brings forward does not lend itself to reciprocal discipline. And my argument is that by incorporating those findings, including the mitigation findings, and it's all incorporated, I mean, you know, the aggravation as well as the mitigation, but by incorporating them, those facts are established for the purpose of this case. And the issue then becomes, as I was saying a minute ago, would there have been substantially different discipline? The rule does not tell you how to make that decision. But I think when you look at the difference between the disciplinary systems of Florida and Texas, and you look at examples of results in Texas, it is a more than reasonable conclusion that had this proceeding with these facts established for the purpose of this record gone forward before an evidentiary panel or a district court in Texas, the result would have been substantially different. And that is what the rule requires us to prove under E. I'll be happy to talk further about that, answer questions, but I want to move on.
I understand where you're coming from. I appreciate
Well, I'd like to ask you to flesh out a little more Defense C and just help how we should read the malleable phrase grave injustice if there were consideration of a new 3-year suspension starting today, how that would fit within the phrase grave injustice.
Mr. Graham was telling the board things that he told me, so I'm going to tell you something he asked me, which is, what does grave injustice mean? I don't know. Beyond what the dictionary would tell us it means. The rule doesn't tell us. There are no commentaries to the rules that explain what it is that would satisfy the burden of proving grave injustice. My position is that when you link together these facts, grave injustice is shown.
No, he hasn't been deterred from practicing law during the entire 3-year suspension from Florida, correct?
True.
And as I understand the situation, in a couple of months he'll be out from under the Florida suspension regardless of what this board does.
Probably.
So that he can go practice law in Florida, or
Yes.
under his Florida license in whatever state in which he can get someone to pro hoc vice him in, correct? I'm wondering how you're going to spin that into grave injustice.
And I'll tell you how I'm going to try to. 3 years ago, or 2 years and 8 months ago, he was suspended in Florida. He had to close down his office in Florida and focus his practice in Texas. Closing down his practice in Florida entailed cost, disruption, so on. He also has been publicly sanctioned. Now, 2 years and 8 months later, the state of Texas, the State Bar of Texas, is saying, well, let's sanction him with an additional 3-year suspension that will make him then, if he wants to continue to practice law, close down what he's doing in Texas, get out of all the cases he is involved in Texas, lose the clients he has in Texas at least for 3 years. Then if he wants to practice law, get admitted in some other state, or go back to Florida, apply for reinstatement. That's not automatic at the end of the period of suspension. And then start trying to build a practice in Florida again. Could he do that? Yes. But under these circumstances, where we have the significant variations in the two disciplinary systems, where, and we haven't reached limitations yet, but some of what he was disciplined for in Florida is now barred in Texas. You have the judgment in Florida with those two differences, different system, different requirements, different standards of discipline imposition. You have time-barred portions of the facts on which Florida's order was based. And you have him already having had his practice disrupted. 2002, he started in Florida, 2008 in Texas. And he, to make a living as a lawyer, focused on Texas. Now he's wiped out in Texas and he's got to go back to Florida and try to start again after 3 years. When you link all of those things together, I think that is a grave injustice.
Let's wrap this up. I think we're close to the 1 o'clock time that I had hopefully aspired to hitting. I will say for the record that I appreciate the presentations. You're both done an excellent job of explaining your positions. We will make a decision on this hopefully today and give you notice of it.
I have some cases I'd be happy to leave with you. If you don't want me to, I won't.
Might as well.
Okay. The first is Woods versus William Mercer. Excuse me. And this deals with
discovery rule,
statute of limitations and discovery rule. And I point out again, we don't have a pleading of discovery in this case. There's no evidence about discovery from the commission. So,
well, I'm very familiar with that case because I was actually involved in the trial of the underlying case with the Supreme Court, and I know what that case stands for. I'm not sure it's applicable here, so well, I'll take a look at it again.
Okay. And the second case is the statutory construction case that is Supreme Court of Texas from 2001, which is TGS NOPEC Geophysical Company versus Susan Combs. And excuse me, Ms. Perry.
That's okay. Thank you.
This opinion addresses the statutory construction issue that I believe I discussed with Mr. McKetta earlier about the absence of a provision accepting reciprocal discipline from the operation of 1506A when it does accept compulsory discipline. So with that,
I'm sorry, interestingly though, the first sentence I think of the reciprocal says that upon the information being received, and I'm paraphrasing, the duty to commence action goes on. So one must think about the operation of that sentence versus the operation of Part section 15.06.
And at the risk of trying your patience, you reminded me of something Ms. DeBerry said that I'd like to attempt to correct. She was discussing the definition of professional misconduct. That's 1.06 W2 of the Rules of Disciplinary Procedure. And that rule defines professional misconduct as including attorney conduct that occurs in another state or in DC and results in disciplining. It is the attorney conduct that is the subject of the sanction, not the order of the other jurisdiction. So when 1506A says no attorney may be disciplined for professional misconduct that occurred more than 4 years before the date on which a grievance, and if you look at the definition of grievance, that's basically any writing, before the grievance alleging the professional misconduct is received by the Chief Disciplinary Counsel. So it is a flat prohibition. No attorney may be disciplined. I appreciate the board's attentiveness to the argument today. I've enjoyed appearing before you. I respectfully request that you deny the commission's petition.
Thank you.
Thank you very much. There being nothing else on the docket, we will stand adjourned. Thank you.